Bill Henshaw here again, Constitutional Crisis Channel. And this is another video that relates to the Gorsuch confirmation hearings, but it's a lot more than that. And I start with Gorsuch because he apparently belongs to a loose-knit theoretical group called the Constitution in Exile. And as I read it, their central theory is that a lot of things went wrong in the 1930s with the Supreme Court decisions and the exponential expansion of the Commerce Clause powers of Congress, with which I agree. We're on absolutely the same page there. The problem is that they either don't know what the real issues are, or even worse, they're concealing them. Because you can't make any serious changes in those 5-4 decisions, in my view, unless you attack the constitutionality of the non-existent 14th War Amendment. If you're not ready to do that, then you're ready to concede that there are no states and that the government controls the citizens that it created, and that all they have are privileges, and there's nothing in the way of creator-endowed inalienable rights anywhere in sight. So I'm calling people out like this that belong to, or at least have thought processes like this. The Constitution in Exile group, the NRA is another one, in my view, that continues to plead the Second Amendment after 150 years. You would think they would have learned something by now. Geez, the case is called Presserville, Illinois, 116 U.S., I think 656. I'll look it up for you. It'll be in the thing below here, where the court said that the Second Amendment, in effect, is in a defense to a gun control statute. 150 years. And they're still doing this? Gee, does not anyone there study what the law is and what the Constitution is? There are much better arguments. The same thing goes a forcery, which means with more force, with civil rights organizations. Because all that comes from Section 1 of that good old non-existent 14th War Amendment. If it doesn't exist, there's nothing there. Which is the primary reason why I have a real problem, especially these days, with the LGBT types and the transgender people and all this crap, and they want to get into the bathrooms of their choice. And North Carolina got into a lot of trouble and lost a lot of business by passing law that restricted them from doing that. And that's just recently been changed too, and now the NCAA is going to think it's fine. We'll let you host some of our events in the future. Both of them are going to be hearing from me, the NCAA and North Carolina, asking questions as to why the NCAA invoked sanctions against North Carolina for a law they knew or should have known was unconstitutional. I would love to get an answer to that one, and I probably won't. At least, across the board, writing and correspondence back and forth. If I file a lawsuit, I might, and I think I may actually have standing to do that, as strange as that may seem at first blush. But these are the kind of people that you have to call out and say, what are you doing? Even if you're acting in good faith. Doesn't your legal team know what I know about the 14th Amendment? Didn't they go to law school and learn this? And if they did, why haven't they told you? The obvious reason for me is that, especially with civil rights groups, that you're promoting your own agenda and keeping yourselves in places of power at the expense of your own people, and you're doing it on their backs. That's very unpleasant, but it's also very true, and the sooner the rank and file realize this, the sooner you go away, and you need to go away. We'll get some serious organizations to do some good that are acting on the right principles. And you say the sooner that happens, the better off we are going to be. We get rid of all this 14th Amendment crap, get on with our lives, and put the government back under the control of we the people, the sovereign body politic of the nation and republic.